I'd like to welcome everyone to Widener University Commonwealth Law School. This is our 11th annual John Gedid lecture, and I'd like to take just a moment. Back in 1988, John Gedid, who's here, John, could you please raise your hand? Came to Harrisburg from Pittsburgh, and this was all farmland in the area. And John is the architect and builder of our law school, and we are thrilled to be able to honor him today through the lecture that we're going to listen to tonight. I'd now like to turn the time over to Professor Jill Family, who's the director of our Law and Government Institute, and she'll introduce the program. Thank you.
Thank you. Thank you all for coming. This is a great turnout. It's so good to see all of you. I want to thank Dean Johnson for his support of the Law and Government Institute, as well as my colleagues on the faculty, as well as our alumni. I also want to thank Sandy Grafe, Brian Fernbaugh, also our Law and Government student fellows who are here. They're standing in the back up there, Jocelyn Schultz and Jenna Moscato. They play a very important role in helping me run the Law and Government Institute, and today, among the many things that they're doing is when we get to the question and answer section, they will hand you a microphone so that we can all hear your questions, and also so that PCN can pick up your questions as well. We are so happy to be back. Another year has gone by quickly, and we're here with the latest installment of the Gedid lecture. And as Dean Johnson said, we are so proud and honored to honor John Gedid, one of the founders of our law school, and also the founder of the Law and Government Institute. So I'm the second director of the Law and Government Institute, and it was my honor to take over that directorship from John. So this lecture celebrates the work of outstanding early career legal scholars and John Gedid's enthusiasm and support for our law school, and also for developing legal scholars. The Law and Government Institute is all about public service. The Institute is dedicated to the study of government law, including the role of lawyers in the making and implementation of laws. At Widener Law Commonwealth, students may earn a certificate in government law in addition to their Juris Doctorate degree. Government law is fused into our curriculum here at Widener Law Commonwealth. In fact, our law school was recently named a top school for public service by Pre-Law magazine. The Institute's mission is founded on the idea that government works, that government is a positive force in our society. And at Widener Law Commonwealth, we train lawyers to be a part of that positive force. If you're interested in learning more about the Institute and our programming, we are on Twitter, and you can follow us at WidenerLG, and we are creeping up on 300 followers. So if you would follow and get us over 300, that would really make my week. We're so glad that John and his wife Carol are here this afternoon. And for those of you who this is not your first Gedid lecture, you know that one of our traditions is that we give John a signed program from the lecture. And so at this point, I'm going to have the annual formal presentation of the signed flyer to John, and we also have a gift for his wife Carol to thank her for all her support over the years as well. And so I'll be right back in 1 second. After the lecture, please join us for a reception in the gallery, which if you head out the back of the room and sort of keep heading left, eventually you'll find your way to the gallery. So now it is my pleasure to introduce you to our lecturer. Professor Sophia Lee is Professor of Law and History and Deputy Dean at the University of Pennsylvania Law School. She is a legal historian whose scholarship synthesizes constitutional and administrative law. She has written about administrative agencies' role in shaping constitutional law, civil rights, and labor advocates' challenges to workplace discrimination during the early Cold War, and conservative legal movements in the post-New Deal era. Her book, The Workplace Constitution: From the New Deal to the New Right, was published in 2014 by Cambridge University Press. Her articles can be found in the Yale Law Journal, the Virginia Law Review, and the Law and History Review. She earned her JD and PhD in history from Yale. Please join me in welcoming Professor Sophia Lee.
All right. So I'm going to be talking today about the history and future of what I call administrative constitutionalism. And by that term, I mean to refer to the way administrators, government officials, interpret and implement the Constitution. Now, I wouldn't be surprised if a few of you in the room right now are thinking, what is she talking about? Right? We've all been trained as lawyers, and usually the way we are trained as lawyers is to think of the Constitution as something that courts interpret. I think there's the document out there, we go to the court, and we find out what it means in practice. So what I'm going to actually argue today is that this is a relatively recent approach to thinking about constitutional meaning making. Instead, for most of the nation's history, the Constitution was implemented primarily, and in some instances even exclusively, by administrative agencies. Indeed, agencies can still play, even today, an often overlooked but important role in giving the Constitution practical meaning. So I want to thank Professor Family for inviting me. It is a great honor to be here with all of you. Thank you all for coming, and also really an honor to offer a lecture in the name of a government law giant like John Gedid. So I'm very thrilled to be here with you. Just to give you an overview of what I'm going to do, I'm going to start by talking just a little bit more about what administrative constitutionalism is, give you a couple examples, concrete examples, and talk a little bit about why I think it's important. Then the bulk of the lecture is going to be providing a sketch of its history, and we'll be arguing during this sketch that if you really look across the broad sweep of United States history, for much of it, administrative agencies played a far greater role than courts in determining the Constitution's meaning. I'll end by discussing how this balance shifted in the 20th century, and then close by briefly considering what the future of administrative constitutionalism is likely to be, especially given the changes that are likely in the Supreme Court's personnel. This is a timely moment to have that conversation, given the confirmation hearings unfolding as we are meeting here now. So let me start with what is administrative constitutionalism? Why do I think it is important? So, what is it? This was a term I coined when I was working on my book, The Workplace Constitution: From the New Deal to the New Right. And just to give you a heads up, you will see throughout these slides a number of advertisements for books that are also in the bibliography I gave you as a handout, and are at the same time serving as a bit of my a visual footnote of sorts, given that I'm going to be talking about a lot of different scholars' work here today. So I coined the term when I was working on the book, The Workplace Constitution, and I came up with it to make sense of materials I was finding in the archives, particularly agency rules and decisions I encountered from around the 1940s through the 1970s, in which agencies were adopting equal employment policies based on their interpretation of the Constitution. And these stood out to me, and I'll give you a couple examples to explain why these stood out to me. So just one example, I found that the National Labor Relations Board, the NLRB, and the FCC, the Federal Communications Commission, were interpreting the state action doctrine differently than the courts, more broadly than the courts were at the time. And just for a reminder, the state action doctrine is a rule that says that the Equal Protection Clause, its guarantees, are only apply to actions of the state and its agents. Okay? In the courts at the time, courts were generally requiring some kind of affirmative action by the state in order to trigger those equal protection guarantees. Federal agencies I was looking at, in contrast, were finding sufficient state action even when the government was only tacitly tolerating private discrimination. So just if an agency was regulating in an area and the entities it was regulating were engaging in discrimination, these agencies were saying that's enough state action to find that, that we are constitutionally obligated to do something about the discrimination. Another example of what I found was agency officials working through separation of powers questions that were unaddressed by the courts at the time. One example is the question of whether an agency charged with implementing a statute that the agency was concerned had constitutional defects had to just implement the statute that Congress had passed it and wait for the courts to sort of sort that out, or the agency had a role itself in deciding not to implement aspects of the statute that it found to be unconstitutional, or to interpret the statute to avoid those kinds of constitutional questions or problems. So that's how these things I found in the archive, I didn't really know what to do with them, and I came up with this term to try to understand what these agencies were doing and begin to systematically talk about it and give it a history. Now, since then, a number of other historians have discovered novel or divergent constitutional policies in agency records, dating all the way back to the nation's founding. And so there's now I'm no longer alone in using this term for historical work. So why is it important? Why should we care about this history of administrative constitutionalism? Well, these findings, my own and those of these other historians, I think have really transformed aspects of our history, our understanding of constitutional history. And I'm just going to give you another example. Welfare recipients. We think of the classic welfare rights case, Goldberg v. Kelly, 1970s, as a creature of the welfare rights movement and legal service lawyers in the late 1960s. Karen Taney, a historian who's at UC Berkeley, has changed the history of welfare rights. Rather than dating the idea of recipients' due process rights in the welfare process to this kind of legal advocacy and social movement activism of the late 1960s, she's actually shown, and this is my advertisement for her book, she has actually shown in this great new book and in some articles that preceded it that those rights, those theories of due process rights actually originated within the federal Social Security Administration with officials who worked them out and tried to implement them from within the agency during the 1940s, so decades before Goldberg v. Kelly comes around. So, agencies have implemented the Constitution differently than the courts, right? That's the state action doctrine story. They've interpreted the Constitution in the absence of court review. That's the structural constitutional questions I talked about. And then they've also forged the constitutional interpretations that were later adopted by the courts. That's really Karen Taney's story. In other words, I think you really can't fully understand the history of the Constitution unless you understand the history of administrative constitutionalism. Okay. But if administrative constitutionalism is a significant part of American constitutional history, then it's important to begin to move from these kind of individual histories of its practice at a particular agency, a particular moment in time, toward telling the history of administrative constitutionalism itself. And in current work, that's exactly what I am doing. Now, writing this history of administrative constitutionalism is a task that really depends on and benefits from some excellent work that has been done in the history of administration generally, and my fellow historians working on the history of administrative constitutionalism particularly. Again, you'll find a lot of that work cited in the bibliography, and you'll see either the authors or their book covers throughout the slide presentation here. Now, this is still a relatively new field, and there's much that remains to be written, but what I'm going to argue today is that, at least based on what we know so far, administrative agencies have been the primary interpreters and implementers of the federal Constitution throughout the history of the United States. Now, that said, the scale and scope of administrative constitutionalism has changed significantly over time, and I will talk about some of those changes. And I ultimately am going to argue that courts have cast an increasingly long shadow over the administered Constitution, as they have over constitutional law more generally. But again, this is a fairly recent, if you look at the big sweep of our country's history, a fairly recent occurrence. So the result is that administrative constitutionalism may still be the most frequent form of constitutional governance. I think administrators still today implement policies that have constitutional significance more than courts do, just as a matter of volume. But paradoxically, it has grown more suspect, even as it has also become far more dependent on and deferential to judicial interpretations of the Constitution. So that's the nutshell of the argument. What I'm going to do now is take a deeper dive into the history itself, and I'll be focusing on the role of government institutions, the court, the president, Congress, and agencies in structuring administrative constitutionalism. This is going to also be a sweep in about a half hour of 200 plus years of history. So we're going to be up at about 30,000 or maybe even 50,000 feet. And I'm counting on everyone in this room being as much of a government geek as I am, because we will be throwing around a lot of these institutional names, and there are not going to be a lot of gripping personal stories here today, but I hope you'll bear with me. Okay, so let's start with the Constitution's administrative foundations. This is the period, what we historians like to call the long 19th century, from the founding up to the turn of the 20th century. And this was a period of opportunity rather than constraint for administrative constitutionalism. That said, the Civil War marked an important shift as the growth in opportunities for administrative constitutionalism far outpaced those in constraints. So I'm going to use the Civil War as a kind of punctuation mark in this long 19th century. So let's start before the punctuation mark, right? This is the period of early America, and look at what it was like to administer the Constitution in early America. So the Constitution, once it was ratified, left many open and burning questions about the new nation, right? We know just then, as it is today, it is not a document that gives very detailed code-like answers to questions. It gives some broad principles and leaves many questions about how to implement its charges. But the courts did not have much to say about those constitutional questions. Federal courts rarely even reviewed the constitutionality of the laws that Congress enacted in the early American period, and they did not review at all. And I'm relying here on the work of Jerry Mashaw. This is a wonderful book on administration in the 19th century that I highly recommend. They did not review at all the constitutionality of the acts of government officials as they went about the business of administering the territories, collecting customs, delivering the mails. Instead, affected individuals who were unhappy with something a government official had done were limited to bringing ordinary private lawsuits, a common law action against a federal official, but in their personal capacity, right? A tort suit or contract suit, something like that. And while Congress and the president may have weighed in on some constitutional issues, there were many more instances of ordinary administrators deciding what the Constitution meant in practice. So this is Greg Oblowski. His book is not out yet. He is a former graduate student of ours at Penn who's now at Stanford, who's been writing about early America and looking at administrative constitutionalism, among other things, in that period. And he has written about how it was largely federal administrators who gave concrete meaning to the Constitution's sparse, really sparse, framework for Indian affairs. And in an era when courts deferred questions of due process, they did not engage whether a government official or agency was giving people due process of law, and Congress was really setting only the most skeletal adjudicatory processes in the statutes that it enacted. Administrators were left to determine what procedures sufficed. So Indian affairs, due process, these are examples where administrators were really charting the course in terms of constitutional protections. Now, when Congress and the courts did weigh in on constitutional questions, it was mainly to codify the answers that had been worked out in the first instance by administrators. So, for instance, and again, this is building on Oblowski's work, when the Supreme Court first addressed Indian affairs in the 1830s, it adopted the view of federal power that had been worked out by the executive branch. What about the president? Presidential oversight of administration was also so limited as to make the administrator's constitutionalism theirs and not his. Right? So we can't just chalk this all up to this is really an exercise of presidential power. And here, Oblowski's work is again instructive. He's shown that even where presidents were most involved on pressing issues such as the federal authority over Indian relations, resolving this structural constitutional question, this was a burning one during the Washington administration, but resolving this structural constitutional question relied as much or even more so on administrators as on the president. And as he describes in other work, administrators didn't even bother the president, President Washington, that is, with other kinds of constitutional questions, particularly those that were roiling the territories. He has a great quote from an administrator basically saying, don't bother him with that. He doesn't want to hear about these kinds of issues, right? Even if we think about the Jacksonian period, right? Here we have President Jackson. This is a time when presidentialism has gotten much stronger, but here Jerry Mashaw contends that administration's growing scale and scope and complexity actually reduced political control by the president and Congress. So even as the president is getting more powerful, administration is getting bigger and more complex, and the president's ability to really direct and oversee it is, if anything, diminished. So by the time we get to the Civil War, that punctuation mark, emerging scholarship suggests that most constitutional questions were resolved in the first and often in the last or only instance by administrators. So let's skip past our punctuation mark and look at administrative constitutionalism during Reconstruction and the Gilded Age, that last half of that long, or last third of that long 19th century. Now, administration expanded notably after the Civil War. Meanwhile, the courts and the political branch's involvement in administration remained scant. As a result, if anything, administrators' primacy in constitutional interpretation and implementation increased during the last decades of the 19th century. So let's back up and just develop that out a little bit. There were many forces that multiplied administration and its opportunities for constitutionalism in this period. When we think about the Civil War alone, it generated a massive increase in the administration of war pensions. Reconstruction and industrialization also led Congress to create a number of new agencies. These included the Freedmen's Bureau, as well as the Interstate Commerce Commission. This is when the Departments of Agriculture, Labor, Justice, and Education were created. So a big period for the growth of administration at the federal level. During this period, Congress also charged agencies with multiple constitutionally relevant duties. So it isn't just creating more agencies, but it's also giving them jobs that really required them to answer constitutionally relevant questions. So just to give an example from the Freedmen's Bureau again, we have the Freedmen's Bureau implementing the Constitution's, at that time, the Constitution's newest amendment, and really generating the first interpretations of what involuntary servitude meant on the ground. Another example is the Comstock Act of 1837, which empowered the post office to exclude obscene materials from the mails, basically putting postal officials in charge of deciding what speech to allow and what speech to censor, something we would today think of as a core First Amendment question. During this time, agencies remained relatively free of congressional direction as they implemented these constitutionally relevant provisions or filled in these kinds of constitutionally sensitive statutory gaps. So for instance, even as Congress gave administrators new duties, it said little about agency procedure and continuing to leave administrators in charge of determining what kind of process would be due to those they were regulating. And the president, right, got to remember the president there. If anything, the president during this period was a weaker check on administrative constitutionalism than he had been before the Civil War. And this is largely because there were a series of weak presidents that followed after Lincoln's assassination. Another factor, and here I'm relying on the work of Stephen Skowronek, who is a sort of renowned scholar of the presidency. But another factor was electoral instability during this period. You had divided government, you had control of government switching back and forth each time there was an election, which further ensured that the president, to use Skowronek's words, never rose far above the status of a clerk, right? That's how he would describe the president in this period. How about the courts? Judicial review also remained a weak check on administration during this period, including the constitutional questions that it raised. During the last decades of the 1800s, Jerry Mashaw argues that courts gradually moved towards reconceiving judicial review as not simply review of a private lawsuit between individuals, but of a public action that was designed to control official behavior. So there was an important conceptual shift towards judicial review of agency actions, yet the space that was opened up for this kind of review remained very narrow. And the court mostly remained disinterested, if not hostile, to constitutional challenges to official behavior. So just to give you an example, may be shocking to you, it's a sort of a startling quote for me the first time I heard it in terms of illustrating this point. This is from a late 19th century Supreme Court opinion that involved a due process challenge to an agency action, and the court's response was, and this is just quoting from the opinion, due process of law does not necessarily require the interference of the judicial power. Courts were irritated by these claims and they did not want to hear them. In fact, the first treatise of on administrative law, which was published in 1903, said that as a statute, a federal statute granting judicial review of the reasonableness of administrators' exercise of their discretion would be unconstitutional. Right? This is just a very different time in the way people thought about the relationship between courts and agencies. And as in the earlier part of the 19th century, when Congress and the courts did weigh in on constitutional questions, it was generally to codify the work of administrators. And just another pitch for a scholar, Anuj Desai, who's cited in the handout, has shown that when the court in 1878 in Ex parte Jackson weighed in on the Fourth Amendment protections for letters in the mails, can they open your letter, and was that going to be an unreasonable search to do so? The court basically adopted a view of letters' privacy that had been developed by postal officials in the first place, right? So it's really administrators working out these constitutional questions, The court may come along and address them in rare instances. This was a rare instance where the court did address a constitutional issue involving administration, but it just adopted the basic understanding worked out by the administrators themselves. Okay, so let's move forward in time and next talk about the progressive era administrative constitutionalism. So this is really the period between the turn of the century and the New Deal that we're talking about. Now, this was also a time when administration continued to multiply and develop greater independence from the political branches, further expanding the opportunities for administrative constitutionalism. Federal courts did grow more watchful during this period, but judicial review nonetheless remained a weak constraint on agencies that pursued those kinds of opportunities. So again, back up, unpack that a little bit. The factors that contributed to the expansion of administration during the progressive era are legion. I could probably spend a 45-minute lecture just going over all of them. But it included everything from businesses' ever larger size, the massive rise in accidents that were created by new technologies like railroads and industrialization of workplaces, waves of immigration, growing faith in technocratic expertise. All of these led the nation towards expansion of administration. And, not surprisingly, the number of agencies and their tasks grew. So we saw Congress creating new agencies, such as the Federal Trade Commission. This is when it comes into being. Also a hodgepodge of public corporations. This is a sort of advertisement or poster for the U.S. Emergency Fleet Corporation during World War I. In addition, already existing departments got new responsibilities. So this is a time where the Department of Agriculture starts regulating food and drugs for the first time. And as administration expanded, as administration got these new jobs, so did the opportunities for administrative constitutionalism. Just to give a few examples, federal regulation of the radios, something else that was new in this period. Well, this expanded administrators' power to censor speech. No longer are we just thinking about the males and raising censorship issues. Now we are thinking about regulation of the radio as well. The newly added 16th Amendment required government lawyers to implement their understanding of the government's new constitutional power to levy an income tax. And that federal income tax also constituted a huge increase in the government's ability to surveil and inspect both businesses and the public, raising a whole host of Fourth Amendment concerns that also were really left to administrators to work out. During this period, Congress continued to follow rather than lead agencies' implementation of the Constitution. So Congress policed administration through high-profile investigations. This is a cartoon about one of those investigations, the Teapot Dome scandal. Any history buffs or government buffs may have heard of it before. But that was largely what Congress was doing. It was like a catch-up game of some high-profile investigations, not any kind of detailed ex-ante instructions to agencies regarding agency procedure, their regulation of privacy and speech, etc. And despite a series of strong presidencies, right, this is a period where we do have some really powerful presidents. Think of Roosevelt, Teddy Roosevelt, think of Woodrow Wilson. Nonetheless, agencies really continued to own their constitutionally salient policies during this period because those presidents' ability to check administrative action was constrained, again, by divided government and even by their limited sway over their own party allies in Congress. What about the courts? So this is a period where the courts did step up their review of administration, particularly regarding constitutional limits on agency action. And here I would really recommend Daniel Ernst's Tocqueville's Nightmare as a great recent book on this period and working out the kind of rapprochement between courts and agencies. So in 1902, just to give, again, a couple examples, the Supreme Court for the first time recognized a general principle of judicial review of agency action, so that really cracked open a new role for the courts in terms of overseeing what agencies were doing. At the same time, courts ate away at their deference to agencies' factual findings, carving out new categories of facts that would be reviewed de novo in the courts. And their willingness to review agencies' procedures also grew. So less of that kind of dismissive, don't irritate me with those kinds of claims, words coming from the Supreme Court. But there were pronounced limits on this newly robust judicial oversight, which left agencies plenty of discretion regarding the scope of constitutional protections. And in a range of constitutionally sensitive areas, judicial deference and vague doctrine left agencies a free hand. And just to, again, to give some examples, here's someone, it's an article, not a book, so you get a picture of Ruhl Schiller. His article, Free Speech and Expertise, really interestingly documents how deference doctrines, the judicial deference to administrators' decisions about permissible speech on the radio and through the mails essentially left administrators in charge of determining the scope of First Amendment protections. In the sphere of immigration, another great book by Lucy Salyer argues that judges didn't see their oversight of agency procedure as she puts it, particularly essential or relevant. So still some of that flavor, not really our problem, don't bother us with these kinds of concerns. And in fact, by the 1920s, Stephen Skowronek, that giant of presidentialism that I referred to earlier, he describes, this is a guy who called the presidency essentially the equivalent of a clerk. In this period, by say the 1920s, he describes the institutional politics of American government as being organized around administrative power. So 1920, really still in a period in which administrative power is at the core of what our government is doing. All right, so let's move from there up to the present day. Now, since the New Deal, although administrative constitutionalism has persisted, it has grown more deferential to the courts. It has grown to look more like the world we have all been trained to expect. And perhaps ironically, this deference was accompanied by a lessening rather than an increase in judicial respect for administrative constitutionalism. So you've had administrative agencies become more deferential to the courts, at the same time you've had the courts become less deferential to the administrative agencies. So paint the picture and can walk through the various moving parts of administrative constitutionalism again. New Deal and World War II transformed administration and really unsettled the roles of the court and Congress, the president, and agencies in implementing the Constitution. Great Depression, the war, massively expanded the administrative state. By the end of the New Deal, the work of agencies, according to one historian, had dwarfed the caseload of Congress and the federal courts. But in just a few short years, agencies' mobilization for the Second World War had outstripped the size of those New Deal programs. And this is a clip of James Sparrow's book, The Warfare State, which is a great book. He basically argues the real transformation in American government was World War II, not the New Deal. We think of the New Deal as being this moment where we grew all these alphabet agencies, et cetera. But he argues that whatever growth we had during the New Deal was quickly outstripped, dwarfed by the growth in government that we saw during World War II. The best known example from this period of an interbranch contest over a constitutional question is that of due process. And here I commend to you The Unwieldy American State by Joanna Grisinger, as well as the Ernst Tocqueville's Nightmare book on the last slide. This battle led to several seminal Supreme Court decisions on agency procedure, as well as the 1946 passage of the Administrative Procedure Act. But this battle followed a mostly familiar pattern of agencies' constitutional experimentation, ultimately leading to court and congressional codification, albeit now with a more robust role for the court and a newly systemic codification by Congress. So think of this as kind of a turning point, right? Mostly like the past, but you're starting to see some real shifts towards what became more more prominent in the years after. And so what happens, you have this big battle over due process, doesn't really go so different than before, but at the same time as that's happening, there are changes in judicial review, in lawyering, in legal theory, and in attorneys' roles in agencies that were happening around the same time that really fundamentally changed the dynamics of administrative constitutionalism going forward. In the wake of World War II, this was not a good time for agencies. Their reputation really fell dramatically. This was partly due to agencies' ever more elaborate procedures, which increased their backlogs and led to complaints about inefficiency and slowness. Critics also charged that agencies created to equalize public and corporate power had instead become beholden to industry. Does anybody recognize this face? Ralph Nader. This is a young Ralph Nader, only a few years ahead of all of you, you law students in terms of his career at this point, making a big ruckus and calling the government to task for capture by industry and failing to do its regulating job. There are also cries during this period that agencies were not doing too little, but doing too much and stifling industry. This is one of my favorite slides that I use when I teach administrative law. This is a picture of a cowboy after OSHA, the Occupational Safety and Health Administration, got its hands on him. Right? He's covered in safety gear. You can't even really tell it's a cowboy underneath there anymore. Now, during the next major wave of regulatory legislation in the 1960s and 1970s, Congress responded to the growing distrust of federal agencies. So it still passed ambitious laws that blanketed the economy, touching on everything from civil rights to workplace safety to the environment. And while these laws created some high-profile new agencies, OSHA being perhaps one of them, they also pushed administration in a more hidden direction, funneling work to the local level, populating existing federal agencies with obscure offices, and shifting enforcement activity to ordinary Americans and the private bar. Here's another plug for Sean Farhang's Litigation State, which talks about this real shift in the mode of regulation. In part to respond to those accusations of inefficiency and bloat, agencies also began to outsource more of their work to private contractors and shifted to regulating via rulemaking rather than adjudication. So a lot of changes in administration. But despite agencies' falling reputation, their opportunities to interpret and implement the Constitution persisted, in fact, in some ways even flowered. And just to use an example from my own work, Southern Democrats' stranglehold on Congress diverted action on civil rights in the mid-20th century from the legislative to the executive branch. And as agencies sought ways to advance civil rights, the Constitution provided the authority sometimes that Congress had refused. And this is a picture of Howard Jenkins, who was a member of the National Labor Relations Board and authored some of its constitutionally informed civil rights policies in the 1960s and 70s. Meanwhile, administrators used novel interpretations of the Constitution's due process and equal protection provisions to strengthen federal control over state and local agencies' administration of New Deal welfare programs. That's Karen Taney's work that I talked about at the very beginning of the lecture. An agency's shift to rulemaking provided another avenue for administrative constitutionalism, as agencies from the 1960s all the way to the present day used notice and comment proceedings to formulate constitutionally informed policies and to debate constitutional questions. During this period, presidential and congressional efforts to ramp up oversight of agencies struggled to keep pace with the growing scope and complexity of administrative action, limiting their ability to direct this constitutional policymaking. If we look at Congress, there were efforts to revise committee structure to provide better oversight, but historians have generally concluded that the promise of improved oversight went mostly unfulfilled. I think by most people's measures, the president was more successful at centralizing and expanding oversight of agency action. This was accomplished through issuing a range of different different strategies. This included the growth of the White House's executive office. It also included using executive orders to impose cost-benefit and other analyses on agencies. But in some ways, the very growth of this oversight apparatus diffused its impact. And indeed, there's a great study, which is not on the reading list, by Lisa Bressman and Michael Vandenberg from 2006, that found that although agencies heard policy directives regularly from the White House, those directives came, there's so many people at this point in the White House, those policy directives came from different sources and often pointed in totally different directions, right? So this executive control is being administered by so many people that it is rarely actually steering government in any one direction. So as a result, agencies really retained wide latitude from Congress and the president when interpreting the Constitution. And persistent limits on judicial review also left ample space for administrative constitutionalism to thrive. The Warren and Burger courts did expand avenues for courts to impose their constitutional interpretations on agencies. They did this through things like recognizing constitutional torts, expanding standing, eroding agencies' exclusive jurisdiction. But by the mid-1970s, the tide had turned and the court was using those same levers to narrow access to judicial review. At the same time, if you think about where government grew in the late 20th century, particularly it involved areas such as national security, immigration enforcement, criminal justice, which were areas in which the court showed extra deference to administrators. And even where judicial review was available and robust, the court's own doctrines tended to leave administration of everything from the First, the Fourth, Fifth, and Sixth Amendments largely to agencies' discretion. Also, the sheer amount of agency action and the limited capacity of the courts ensured that even if courts wanted to review questions of constitutional questions of agency policy, they didn't have the capacity to do that. And the court was interestingly, throughout this period, even as it began to be more aggressive in the area of the Constitution, was notably ambiguous about administrative agencies' engagement with the Constitution, casting doubt on it at some times, but leaving space for it at others, and never taking an opportunity presented to shut it down. Agencies' administrative constitutionalism was also encouraged by shifts in lawyering. This is when we think of the birth of the public interest bar. And this ranged from the better-known work of civil rights litigators and legal services lawyers, but also includes the maybe lesser-known advocacy by conservative public interest groups. The Pacific Legal Foundation, I've included here, opened its doors in 1973. And as these lawyers moved in and out of government, they created new avenues for disseminating constitutional arguments within agencies, and also for pressing for the adoption of constitutionally informed policies by agencies from without. So there's a lot going on that was continuing to foster administrative constitutionalism in the last 80 or so years of our history. But even as that was happening, the administrative constitutionalism we were seeing became far more judicialized. And in part, this is due to the court expanding vastly its review of constitutional questions. So in the 1930s, the court began carving out for special protection preferred constitutional rights and politically powerless victims. And started in the area of the First Amendment and spread over subsequent decades out to the Fourth, Fifth, Sixth, and 14th Amendments. The Supreme Court steadily expanded the scope of constitutional provisions it found the government had violated. I've already described how the court also expanded access to judicial review. It also asserted in this period more boldly that its word was the final and possibly the exclusive word on constitutional questions. Another thing that changed is that this period, the rights revolution in the middle of the 20th century really specifically targeted the way laws were administered, giving courts opportunities to weigh in on their administration rather than simply did Congress have the power to pass them at all. And so as a result, the court steadily infused an ever denser body of court-imposed constitutional constraints on administrative action. Now, the Legal Academy also fed the judicialization of administrative constitutionalism. legal process theory, which really dominated jurisprudential thought in the mid-20th century. Anyone who went to law school, I think probably anywhere through the 90s would think of this as a core part of their legal education. And this theory really favored judicial rather than administrative resolution of constitutional questions, because its expounders insisted that implementing the Constitution's rights-bearing provisions required the development of neutral principles. This is a famous article by Herbert Weschler on this very concept of neutral principles. It was a critique of sorts of Brown versus Board of Education. And this was a quintessentially and perhaps distinctly judicial undertaking. I think the court's rights revolution judicialized administrative constitutionalism in less direct ways as well. So part of the New Deal settlement between bench, bar, and agencies turned on securing the role of lawyers within agencies to ensure their compliance with due process and other legal values. So this is a period really in which the jobs for lawyers and agencies grew dramatically. And those lawyers, as a result of their training, the same training we all got in law school, brought with them a focus on judicial precedent, an idea that that's where we look to think about what the agency could do. And whereas before they might have had no choice but to reason from constitutional first principles or agency custom, the fact that the court was producing so many more cases on constitutional questions meant that they now had ample judicial sources to turn to. So over the last 80 years or so, administrative constitutionalism has persisted, but has also been judicialized. Agencies are perhaps less likely to see answering constitutional questions as part of their job, and when they do pursue those answers, they're more likely to either rely or at least dress up their interpretations in judicial precedent. And this has happened at the same time that courts have insisted more forcefully that theirs is the primary and even exclusive and final word on constitutional interpretation. So really, scholars have just begun uncovering this history of administrative constitutionalism, but based on what we know so far, for much of the United States history, agencies have had a relatively free hand in implementing constitutionally sensitive policies, in resolving structural constitutional questions, and determining what the Constitution's rights-bearing provisions mean in practice. And even as administrative constitutionalism has become more judicialized in the last century, and courts have insisted on a greater monopoly over constitutional law, the practice has persisted. So what? One, I think that this is important for history, right? If the outline that I've sketched here is accurate, it indicates that our histories of American constitutional law, of administration, of politics, are woefully incomplete without a greater attention to how administrators have implemented and interpreted the Constitution across time. They clearly have done it. How have they done it? I think this is also important for the future. And I say that because the story of administrative constitutionalism is also a lens through which we can view the history of administration itself. And throughout the nation's history, the opportunities for and constraints on administrative constitutionalism have, to a great extent, mirrored those on administration more generally. As a result, I think its future is likely linked to the future of a range of deference doctrines that have formed a core of administrative law, at least at the federal level, ever since courts opened up judicial review of agency action around the turn of the 20th century. So that brings us to what is happening right now, and perhaps still in this moment on the floor of the Senate. President Trump's nominee for the Supreme Court, Judge Neil Gorsuch, is among a growing number of jurists. I will say one or more. I think Alito's position on this question is exactly where he grounds it is a little, still a little hazy. One or more of whom are already on the court, who contend that courts' deference to agency interpretations of law is a violation of separation of powers and an abdication of the judicial duty to say what the law is. Now, if they feel that way about agency interpretations of statutes and of their own agency's own regulations, I expect that they would feel the same way about agencies' interpretation of the Constitution. I think that's even a harder case than regulations or statutes. So what does the history of administrative constitutionalism offer to this debate? I hope that this history has made clear that there's nothing new about administration being at the core of the government's exercise of power, or new about administrators taking a lead in interpreting and implementing the law, indeed even drafting the law. As this history has also made clear, though, administration has really grown in its scale and scope over the nation's history, and the other branches have had a hard time keeping up in terms of maintaining the balance of powers. Now, it's possible that administration has grown so much that the more aggressive judicial review that Judge Gorsuch and others have called for is needed to maintain the balance of powers. I think that's a possible argument one could make. But I think if we're going to go in that direction, we need to be honest that this would be a functional adaptation to relatively recent changes in our government. We're not going to get to that outcome by relying on an originalist account of a judicial power that we imagined back in the early 19th century that has been abdicated and needs to be reclaimed. So I think that the history of administrative constitutionalism helps us begin to answer that question as a matter of originalism, and to sort of frame what the problem might be that is creating the question in the first place. And I'll end there. Thank you very much.